Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land. I'm the Moorish Empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and just get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. God dang, you're right. Moorish Empire. Traveler on the land. Bitch snitch. Moorish Empire. God dang, you're right. Traveler on the land. Bitch snitch. Late evening U.S. people.
What do you got?
I think I can prove to a judge that both of these men had the mens rea.
What the hell is a mens rea?
It's a legal term the lawyers use. It just means the intention to commit a crime.
Okay, come on, let's go.
Mens rea?
Put the cuffs on him.
How could we have gotten mens rea? We take blood? Can you do it without taking blood? We both use condoms. How is this possible? I want to see a doctor. Can I have an independent blood test?
Money!
I feel sick.
What are you doing?
Mens rea! Oh! Oh! My God! No!
Hey, good morning, good afternoon, good evening, good night, everybody, whoever you are, wherever you are, whatever you're doing, whoever you're doing it with, however good it feels, however many times you're going to do it, and why you're doing it in the first place. I don't care. I'm just glad you're doing it here with me, Legal Vices, on this little channel we like to call Legal Vices. It is Wednesday, and I'm super extra happy because it's Wednesday night here, and tomorrow is a holiday here in Korea. It's a liberation from Japan holiday. Gwangbokjeol it's called. So it's like a Korean Independence Day tomorrow. So no worky for Jeffy. So I'm excited about that, which means I can kind of chill a little bit tonight, which is good because I've been a little bit stressed, but now I get a day just to chill. And then I work one more day, and then it's the weekend. What more could you ask for? It is Wednesday, and welcome. Now there's a couple of things here. We are going to be watching the I almost said Boone. Don't know why I almost said that. Mary Jane, not really. Sarah asks, Korea was a part of Japan. No, Japan has invaded Korea numerous times over the past couple thousand years. So this is one of the liberation from Japan days. Excuse me, Flux. What are you confused about, Flux? Why are you confused? It's not good if Flux is confused. But she's confused about something. We're not sure what it is. So, all right. We're going to be watching the status hearing, the Sarah Boone status hearing from last Friday, not the one that's happening today. According to Jules, who's up on all things court-related, today's status hearing is supposed to be starting at 1:30 p.m. Eastern time. So this is last week's. I have not watched it yet. I am walking into this cold. I've been a good boy, and I haven't watched it because I want to react live. I want to get in on it. So That's what we're going to be doing. And it should take the entire 2 hours, after which I don't know what I'm going to do. I'll do something, probably to go out for a nice long walk because I can. Tonight is actually the second night in 2.5 months it's been cool enough to turn off the air conditioning and open the windows. It's still hot and sticky and humid, but it's cool. If that makes any sense. It's cooler and there's a slight breeze blowing. All right. So if you're watching on the replay crew, skip ahead about 5 more minutes while we get rid of no, the door is slamming shut because of the slight breeze. Hang on. Must move something in front of the door. There we go. As I was saying before, I was so rudely interrupted by nature. If you're on the replay crew and you don't want to watch the fellowship and philosophize, and skip ahead about 5 more minutes, just scroll across till you see our little intermission, and that's when the main focus of today will begin. Let's see. So before we jump into it, we have to do a couple of things. First, the one thing I promised I would do something yesterday. We have our goals. We have goals to achieve. We've achieved Doggo Cam, the emotional support potato pig dog cam, 2 days in a row. Let's see if we can keep the Doggo Cam streak alive. We've got the 2 dogs lined up and waiting for their 15 minutes or 2 hours on camera, depending how long it takes to get there. Let's see if we can keep the streak alive at 3 days today. And then the second goal is a $200 goal where when we get there, we do a punishment shot. And the third goal, which is at the next 100, is a mixture of a punishment and reward shot, which is a double shot of absinthe. And I was going to explain one of the ways to tell real absinthe from fake absinthe. One of the ways to tell real absinthe is what's called loaching, where if you put nice cold water into it, it'll change color, basically. As I was saying yesterday, let's see if we can get this in focus. Here's a little pour of absinthe. This is about as green as real absinthe should be. If it's blue, if it's bright green, if it's neon green, if it's glowing, if it's turquoise, it's probably fake. Not probably, well, it's most likely fake. But, excuse me. One of the surefire ways to tell is to pour cold water. You should drink absinthe with like a sugar cube and then drizzle ice cold water over the sugar cube to kind of sweeten it up a little bit and dilute it a little bit. But what's called loaching happens. See how nice and green and clear it is? Ooh, gotta be careful. I don't want to pour a container of water onto there's easier ways of doing this, but I didn't bring another cup with me. How am I gonna do this? Because like my hand is sweaty. All right. There's water condensing on the side. We'll just do this. If you pour it in, it'll do what's called loaching. It'll turn milky. See, there we go. You see how that turned a nice milky color? So it becomes opaque and milky. That's called loaching. And somehow I got a piece of cigar in there. So that's called loaching. That is what real absinthe does. So there you know. That's what I was going to show everybody. I promised I would show them today. And I did. So mission accomplished. And if we get to the 300 part, we will just add some more absinthe to it and drink it. Right. Let's see. The second thing we need to do is, again, remind you that this is a hearing. It's a recorded hearing. It was recorded last Friday. So contrary to normal courtroom practice, where I'll withhold I'll flash the super chats up on stream and I'll withhold them until I'll read them at the breaks in sidebars during normal breaks, changing witnesses, whatever. This is recording. We got a little bit of time. We've got some freedom. So we can just bring them up as they come in. And, do not forget to take our like and subscribe poll. We've currently got 213 people here waiting for me to get on with it. Jump on over here, take the like and subscribe poll. Today, again, the like and subscribe poll. The only purpose is to remind you to actually hit the like button and to subscribe. And if you are subscribed, just double check to make sure you're still subscribed. We're working our way towards 90,000 now. That play button's coming, people. So subscribe and vote. Today's poll is Sarah Boone is confused. Sarah Boone doesn't know what to do. Those are both phrases she's used repeatedly in her status hearings. I'm confused, or I don't know what to do. And the third option is Sarah Boone is smarter than you, because during her initial interview with the police, she made sure to tell them that she was an all straight A student. And just on the jokey side, Sarah Boone has an airtight alibi. Waka, waka, waka. Okay, there we go. That's just our silly, ridiculous post. So make sure you hit the like button, hit the subscribe button, get on over there and do all that stuff. And tell your friends about this so we can grow the channel, because that's what it's all about. Getting more people into the Vice Squad chat, which is the greatest chat on the internet. I've run out of things to talk about. We need to get into the meat and bones of the show, which is last Friday's hearing. The hearing that's scheduled for today is going to be in 11, 12, it's going to be in 4 hours, at which time I will either not be home or I will be asleep, one of the two. So we'll probably watch that Friday. If not, we'll watch it sometime soon. All right. It is now that intermission time, so stand back and get ready for the real beginning of the show. Let's kick it off, shall we? Where's our little old brand? So those of you that are fast forwarding, this is where you should fast forward to.
This is a brief intermission.
You're very much appreciated for saying that I'm appreciated. I appreciate that.
This is a brief intermission.
Thank you very, very much. I'm going to have a search and or seizure. More likely the seizure. I appreciate you.
This is a brief intermission.
I appreciate you. All right, here we are. We are going to be covering the Sarah Boone status hearing from last Friday. Before we get into that, we have to do a very, very important thing. Whilst we were doing the fellowship and philosophizing at the beginning, Sonny or Chris dropped the big un. He dropped 20 Legal Vices memberships. And if you are one of those 20 people that got one of those 20 Legal Vices memberships gifted to you, make sure you give Sonny or Chris a super wonderful thank you and welcome to the memberships. We will definitely be having a membership stream this weekend, I promise. Don't know when, but stand by. Make sure you sign up for the notifications. Thank you so much, and you get the big old foghorn for that. Thank you very, very much. That instantly takes us to our first goal. We've achieved goal number 1, and now we are beginning our trip to goal number 2. Goal number 1, of course, is that goal that we just love to call Release the Hose. And there's Yoda, nestled all snug in his little bed, and Strawberry is again underneath the bed for the time being. So there's the sleeping Yoda. The sleeping Strawberry is on the floor outside of camera range. So thank you very much to Sonny or Chris for getting us there right out of the gate. Boom. All right, thank you so much. All right, people, let's strap ourselves in. Let's buckle ourselves, handcuff ourselves to the jury box, because we are now going to start the hearing. And keep those super chats coming. Yum, yum, yum. They taste good, because I'm going to light up a cigar. Light up a cigar if you got one. Now get yourself some popcorn or whatever. And me, as a beverage to keep me through the night, I have prepared some sweet Boone Tang. Some sweet Boone Tang. See, that's Tang, sweet Boone Tang. Heavily diluted with vodka. So I'll just be sipping on that Boone Tang through the whole thing. Delish. All right. Enough of that silliness. Let's get on with it. And go. I can see that they're doing what they did last week as well. What they did in the previous hearing. We've got it in stereo. People over here, we got people in our left ear, and we got Sarah in our right ear. We got people, it's in stereo, like the late 70s when, like mid to late 70s when hi-fi was starting to become a thing, and the musicians would just screw around with the back and forth to the right and left ear. That's kind of what we got here today.
Dave Ketcher on behalf of the state.
William J. for the state.
Ma'am, good morning. Can you raise your right hand? Madam Clerk will swear you in.
You swear or affirm that the testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
All Ma'am, good morning, rather. Could you state?
Wow, we go from not being able to hear anybody to judge being way overmodulated. Luckily we have some of those closed captions. We got some closed captions here for this, so you can follow along and be amused at the mistakes that are made in the closed captioning. But the judge is very loud. We can hear Sarah this time. That's good. And this may be the last time we see her in that chair, because she has asked, one of the motions they're going to be hearing today is the motion for her to be allowed to move freely in the courtroom, to be unhandcuffed and unleg shackled, so that she can move about and not be restricted to being chained to the jury box there. And she's got her folder with her. Let's see what she's going to be talking about today.
Your full name and date of birth for the record for me. Okay, we had a hearing this Monday on August the 5th. The court had entered a scheduling order and notice of hearings. Ma'am, that was sent to you by way of mail. Did you receive that?
I did yesterday.
Okay, all right.
There you go.
I know that you had brought up concerns regarding mailing, and I just wanted to go through the historics with regard to the mailing. As you may recall, back on June 28th, we had a hearing where I granted Ms. Cushman's motion to withdraw and addressed your forfeiture, alternatively a waiver to counsel. You were hand-delivered a copy.
Okay, if you remember from yesterday, part 1 of our 2-part Sarah Boone series, 2 of her motions dealt with immediate change of her address. Apparently, something happened at this June 28th hearing that meant she was getting her mail sent to the wrong place. Her legal mail was being sent to the wrong place, and she wanted explanations, and she wanted it changed to her proper legal document mailing address. So that's what I think they're going to be talking about now. He's going to be explaining what happened and rectification
Of that order. On May 25, we had a hearing and an order was entered and a notice of hearing was set. That order was hand delivered to you. Mm-hmm. Thereafter, there was an order setting hearing that was entered on July 29. That letter, or that order rather, was sent to you at P.O. Box 9109, Seminole, Florida 33775, which is the Orange County Corrections Department mail address for general inmate mail. That was remedied the next day. On July 30th, a certificate of service was entered to the appropriate address, identifying you, your inmate number, FDC-B4, P.O. Box 4970, Orlando, Florida 32802, which is the address that you had placed in your motion and your notice. That certificate of service included the notice of filing of the memorandum from the Orange County Corrections Department, Security Operations, and there was also a certificate of service providing you the Justice Administrative Commission's response to motions seeking due process costs. The next mailings was a notice of mailing of documents by your former attorney, Patricia Cashman, which was the transcripts of depositions of detectives Chelsea Copsell and Scott Lowen, which were taken on May 7th, 2024. That was e-filed on August 1st, 2024, and mailed to you with addressed to you, your inmate number, FDC Dorm B, P.O. Box 4970. I apologize. P.O. Box 4970, Orlando, Florida. Did you receive those deposition transcripts?
I did.
Okay. Then the notice of delivery, would you recall when you received those transcripts?
Everything that you are stating was received on Monday.
The 5th?
Correct.
Okay. The next was a notice of delivery of digital copies of documents that was e-filed by your former attorney, Patricia Cashman, on August 1, 2024, which provided the transcripts of depositions of detectives Chelsea Copsell and Scott Lowen taken May 7, 2024 to Billy Lane on August 1st. And that was mailed to you at the same address. We've been addressing P.O. Box 4970 on August 1. Did you receive that notice?
I'm sorry, what was sent that for?
Notice of delivery of digital copies of documents, which reflected the deposition transcripts of the detectives I just identified to Mr. Lane.
To be honest with you, I don't know. It was a lump sum of a giant amount of paperwork, and I haven't gone through it yet.
Okay.
They had me sign about 4 or 5.
Wait. Miss, I can't get my stuff to me fast enough. Miss, where's my stuff been? Miss, I want my discovery now. She was given something a long ass time ago. Well, there was too many of them. I haven't gone through them yet. Now, come on, you cannot complain that you're not getting documents, but then you say that you got a lot of documents earlier that you still haven't gone through. Come on, Sarah. Come on. You're making people lose sympathy for you when you do that. Keep it consistent.
Received.
And the last was a certificate of service that was just e-filed on May the 5th, which was provided to you as well on August the 5th. It was provided to you on August the 5th at the P.O. Box we've identified by way of U.S. mail, which was a copy of the order authorizing the defense to incur costs for private investigator and the scheduling order and notice of hearings entered August 5, 2024. Have you received both of those?
I did, and I had questions on that, please, whenever.
In just a moment, ma'am. So I know that there was a concern with regard to mailing and things purportedly not being timely provided to you. There was only one order, the order of July 29th, which was sent to the general mail delivery, and that was remedied the exact next day on July 30th. So that clerical error as to the wrong address was remedied one day after the original order was sent out on July the 29th. I just wanted to put that on the record and again, identify for you, ma'am, that nothing's being withheld from you and everything is being timely served to you as required. Now, you had questions about the JAC order. I will revisit those in just a moment. I've got a sticky with regard to that.
And I was going to say, please, if I may, about the address. There were 2 or 3 different documents that were uploaded to the tablet. So those 3 documents, without knowing specifically which ones they are, those were also sent to P.O. Box 9101.
I don't know what you're talking about.
Yeah, I don't
You were
either.
talking about supposedly just one document that was mailed to the incorrect address. It was more than one.
That's not correct. Court scoured the court file this morning, ma'am. The court has not filed anything other than what I've identified since that June 28th order where you were representing yourself pro se. So that is incorrect.
Is it something that I need to record and bring back, or is it that big of a deal?
I can't answer that question. That may call for me providing you legal advice.
Yeah, the judge cannot provide legal advice, can't even point her in the right direction of legal advice. So he can't answer any of those questions like, should I do this? Do I need to do that? What does this do? Yeah, he can't do any of that. But she said something really weird. I said that there was 2 documents that were uploaded to my tablet. They were sent to the wrong address. Perhaps they were served on you on your tablet. That's what the e-service is all about. You get them electronically, not in paper form. So perhaps if she got them on her tablet, perhaps they weren't sent to. She's like, I didn't get them in a hard copy, so they must have been sent to the wrong address. They may not have been sent anywhere, which is what I think the judge is saying. We haven't sent anything to that address, so I think they might be at cross purposes there.
Okay.
But I can't tell you that other than the July 29th order, which was remedied the next day, everything has been sent to the appropriate legal mail address as provided by the Orange County Jail. We've had this hearing today to address a couple of things based on the scheduling order and notice of hearing that was entered August 5. The first was the digital evidence issue. I've been advised, I think through Mr. Lane, who I do see in the courtroom. Mr. Lane, if you could come on up, sir, so Madam Clerk can swear you in.
Oh, this is the what's his face from Prison Break Investigation.
Can you swear or affirm the testimony you should give shall be the truth?
This man has tightly tailored suits. Every suit this guy wears is tailored really tight to him.
Okay, go.
All right, Mr. Lane, good morning, sir. Can you state your full name and your affiliation with Prison Break Investigations, please?
Billy Lane, Chief Investigator, owner of Prison Break Investigation.
Okay. I understand part of the order from Monday was regarding the state's digital evidence. I understand that may have been provided on a USB drive to you, Mr. Lane. I want to hear from the state with regard to that first. So either Mr. J or Mr. Cacciatore.
Yes, Your Honor.
I still think it's funny that the guy from the prosecution side is Mr. Cacciatore. I just think that's funny. But the one thing, and we've mentioned this before, the one thing I really like about this judge is how fair he is. He doesn't get agitated. He doesn't get excited. I've never heard him raise his voice. He's cordial to both sides, and his tone of voice doesn't change whether he's talking to the investigator, whether he's talking to the prosecution side, or whether he's talking to Sarah. Same tone, same voice, same volume. Respect to this judge for doing an amazing job. I think he's one of the best judges I've seen so far.
We have tendered to Mr. Lane a copy of our the exhibit list with our expected items of evidence that will be received, along with expected witnesses that
he has to cover up the full body tattoo
a
of prison
copy of
blueprints.
that was provided.
Oh, that show was good the
USB,
first season.
The exhibits, the witness list, also proposed jury instructions and a stipulation as to victim ID for her review as well.
Okay. And when was that provided to Mr. Lane?
Just now.
Okay. All right.
Okay, so the prosecution just passed off the witness list and all these, they plan on calling and all these other things you just talked about. So they've been sent to him. Now he's got to get it to her.
The witness and exhibit list that is
now she's got 14 days to go through the witness list and the evidence list and make any
That was
objections.
going to be my next question. Okay.
And I have a copy for defense.
Okay, very good. Debbie Bruce, if we can get the copy of the witness list and the exhibits and take that from Mr. Lane and provide it to Ms. Boone.
And you.
Now don't say
And
you
Your
didn't
Honor,
get this, Sarah. Hey, where'd my
the
dog
state's
go?
position is that, given that our exhibit list contains within it a witness list as well, we would ask that document be sealed the way the witness lists are routinely sealed. A copy of that request to seal is there with the notice of the witness list on the initial page before our notice of the exhibit list.
Okay, so he wants the witness list sealed and prevented to be prevented from being revealed publicly, so that people outside the courtroom don't get a look at the witnesses that he plans on calling, to avoid possibly to avoid any contamination, any tampering, anything like that. So I'm pretty sure that's going to happen, but we'll just have to see.
What I have in front of me is the notice of provision of witness list and then the notice of expected evidence and witnesses of trial. I don't have an order or.
It wouldn't be an order. It would just be that first document you read on a reference, the notice of provisional witness list.
Got it. Okay, thank you. All right. Anything else with regard to the expected evidence and digital evidence?
No.
Okay, so just for my own understanding, there are 9 files on the USB drive that are digital in nature. Is that correct?
Yes.
Okay, all right. And those are all on the USB drive that is going to be provided to Ms. Boone?
Yes, they're broken down by folders.
And the folders, are the names of the folders, do they match the names in the digital evidence list?
They roughly match. I believe
They roughly match.
On there may be some slight change of terminology from, I believe, files found on iPhone as opposed to suitcase, videos, and still shot.
Okay, all right. State, anything else to add with regard to the digital evidence?
No, I also have a copy of the thumb drive as well that Mr. Lane has had an opportunity to copy for his client that I can tender to Mr. Lane to tender to his client.
Is that different that we've already given him?
He had an opportunity to copy it, but this would be their copy to retain.
Okay, all right. So you can go ahead and provide that. Do you want to mark that as an exhibit for the purposes of the hearing? I guess not, since it's going to be transferred directly to Mr. Lane.
Correct.
Okay, all right. You can go ahead and give that to Mr. Lane. All right.
And while he's doing that, let's pull this up. Adara the Wholesome has just dropped the $5 super chat. Thank you so much for that. Sarah's last hope at this point is getting with Hartung and performing a seance Suwans summoning Johnny Cochran to rep her and pull the Chewbacca defense. All right. Suwans, I like that. That's what she needs to do. She needs to get with Hartung. She needs to get a hold of a Ouija board and summon Johnny Cochran to help her out. What was that show, the Netflix show where he summoned the ghost of Johnny Cochran and the ghost of Duke Ellington lived in their house? Oh, crap. Anyway, irrelevant. Objection. Irrelevant. All right, let's go.
Ma'am,
Thank you so much for that.
Any other questions? Anything else you want to bring to my attention with regard to the digital evidence?
No, Your Honor.
Okay. Ma'am, have you had the opportunity to review the notice of expected evidence and witnesses at trial document that was just provided to the court and yourself this morning?
I did.
Okay. Do you have any questions with regard to the digital evidence?
Sure she does.
Which are paragraphs 1 through 9 on the first and second pages of the notice.
All right. What are the odds she has questions? I'm guessing it's pretty much 1. It's 1 to 1. She has questions.
I don't know what the majority of them are.
Oh.
Is this part of the
Surprise.
evidence that was supplied to me on all of the USB drives that was supplied also?
Yes, this is a pared down. All of the items referenced in our notice and provided on the USB have already been previously disclosed and given to defense.
Okay.
Okay, that's very nice. Not only have they given her a list of evidence they intend to use at trial, they've actually repackaged them on another thumb drive for her convenience. So she doesn't have to dig through the 2 thumb drives to find the documents that are referred to in those various paragraphs. Yes, Big Mouth, that's what it was. Thank you. Thank you. That's right. They had the ghost of Duke Ellington living in their house. All right. So that's the date of this hearing. Corin Pope, this was, hey, how you doing, by the way, Corin Pope? Good to see you. This was last Friday. There's a hearing that's going to take place in just a little under 4 hours today, but I won't be covering it live. So there we go. This is from last Friday. She's got questions. What could it possibly be?
Any other questions? Yes.
Yes, on the USB drives for the laptop, it's not compatible with the USB drives for some of the files.
What?
So I cannot open a majority of what are on both of the USB drives.
Oops.
What do you mean you cannot open a majority? What can you not open?
I don't know specifically which files. I know that some of them come up as videos, some of them come up as JPEG, some of them come up as different formats. But there's an entire page of multiple icons that come up, and every time I try to open one, it won't let me review it.
Okay.
So I don't know.
What does it say?
I don't know.
Sarah. You know what they say. You write down everything. Why wouldn't you write down the error message? Come on. Is there an error message or is it just a sub file? I doubt they would be zipped. But who knows? My spidey sense, my BS sense is kind of starting to tingle here.
I moved on from that to try to go to other programs. So I don't know. I figured it would be something that I might be able to speak to Billy about when he came to see me early next week. So, but I'm just stating to the court now that's one of the problems that I'm having with the laptop.
But you said it's a majority, but you can't identify specifics for me. And that's what I'm trying to figure out. What is it that you're not able to look at?
And I love that the judge is not letting her get away with her bullshit. If you say the majority, you should at least be able to identify one file or one file type that is not allowing you to open it. You can't just say, I hate when people do. That is my personal trigger. You know, a bunch of people said this. Well, said what? Stuff. Well, what stuff did they say? Give me one specific thing they said, or just stuff. Who said it? Oh, people. Oh my God, I hate that. So she has triggered me here. If a majority of your files won't open, and the judge highly doubts it's a majority, you should be able to identify what is not opening. Come on. it's a .bs file. Duh.
It doesn't identify what they are.
Brad, where's IT Brad? IT goatee Brad, where are you? Sarah needs help. Someone send out an SOS to IT Brad.
Because of the amount, when I click on a particular file.
What file?
There's a file inside of a file inside of a file.
Okay, so there's subdirectories. They've organized it. That's called organization, Sarah. Sarah. Okay, so yeah. They're all organized for me. I don't know what to do.
So when I try to open one of the files, all these different icons come up. So if I try to click on one, it says unavailable. So I keep trying to go to the next one, the next one, and the next one, but they're all the same format, so I can't open any of those.
What format?
Okay.
What format?
And how many times has that happened?
The one time
One
that
file, 10 files, 20 files, 50 files, or was it just a one time and then you moved on to something else?
I don't know how many files were in it because I didn't bother to waste my time on trying to open.
Oh, Jesus.
I believe I tried to open about 8 or 9 of them, and then I just moved on from that folder into another folder.
And the other items in the other folder, were those accessible? Were those viewable?
For the most part, yes. I haven't.
Now she said a majority of them won't open. Now she's just said for the most part they can be read. Damn it, Sarah. Stop it. Stop it, Sarah. You're not helping yourself. I genuinely think she doesn't know what a format is, says Jingleberry. I think she genuinely doesn't know what a lot of things are. But she does use cool words like futuristically and what was the other one that she used yesterday? Pre something that was funny as hell. She made up a word that I really liked, but I can't remember what it was.
And I have not had
I don't know what for the most part means.
I haven't had time yet.
See, this is the law. This is accuracy, specificity is important. You can't just make generalizations and say, on the one hand, the majority of files don't open. I couldn't open these 8 or 9, but by and large, the rest of them open just fine because that was wrong. You can't have both. Prequel? No, it was prequely. That's what it was. It was prequely. Prequely and futuristically. Those were my favorite words from yesterday, from part 1. But yeah, so she, and he's like, okay, you can't be vague. We need, yes, exactly, Daryl Smith. We need specifics. And she's just thinking she can just, half-ass her way. That ain't going to happen. Sarah, you should have had your come to Jesus moment a long time. My dogs are disappearing. Every time I look at my camera, there's a dog missing. There we go. She should have had her come to Jesus moment and realize how serious this predicament is and got her ass in gear. But apparently it hasn't sunk in yet.
To explore everything due to the dorm environment. So as soon as
blame it on the dorm.
The amount of information, the vast amount of information that he has on there, I'm trying to figure out a way where I can sit in it. I have a letter to you that I wrote to the captain, a copy for you.
You read that yesterday.
So you know what I'm trying to work on in order for privacy to be had. So I haven't explored both USB drives to the fullest potential that I possibly can yet. Just from the moment that I have attempted to do so, the one problem I have had was with the one folder with many icons in it. I attempted to open about 8 or 9 of them, could not, so I moved on to whatever was next.
All right.
Whatever.
I could add to that everything that we have provided on this USB file, we have checked. It's all on standard formats. For instance, the public surveillance video that's referenced in our notice, we included both the original Publix files from there, and then we also had those files converted to VLC because they are easier.
Now, VLC will open any goddamn audio or video file you've got out there. VLC is the absolute workhorse of video and audio playing software. You know, it's pretty solid. We'll bring back the doggo cam when a dog returns to the room. Holy crap. Now, if she says she can't view the videos on VLC, Jingleberry, that is weird and way too much information. Yeah, that is the best part of VLC. Well, VLC is not a format, but it can be. They have their own format, don't they? Don't they have a VLC specific, or is it just handling every codec known to mankind? But it can be VLC can play anything. If she has a VLC player and she's saying it can't be played, exactly, Buck. If VLC can't open it, it doesn't need to be opened. Even Strawberry's tapping out. No, yes, VLC is a media player. It handles every codec known to man. And if VLC doesn't work, then something is definitely wrong. Yeah, all of us, or the vast majority of us, are well acquainted with the magical powers of VLC. Like, I don't like the VLC player, but if I got something I can't play, I go, VLC will play it, and it does. So there we go. We need to get to the bottom of this.
To play in VLC, so if she clicks on
that's exactly what I do, Jeff.
Click again on a subfolder, and she will find the VLC files for where the public's video has been converted. So everything in there should be standard JPEG, VLC, and also believe an MP4 for some audio only files.
Okay. All right. Ma'am, do you have any other questions with regard?
She's looking irritated. Jane Bradshaw says, Legal Vices, why do you assume she has VLC on her computer? Because she does. I mean, she's not going to not have VLC on the computer that they provided to her for playing media files.
Or to the digital information or digital evidence identified in the notice that the state's provided to court and yourself this morning.
That was what was just handed to Mr. Lane. So, Mr. Lane, you and I would go over that when you and I meet.
I will be meeting with you tomorrow. There is a concern that I will not be able to transfer this to Ms. Boone through the jail protocol.
I have a remedy for that. With regard to, well, let me finish with the digital. Any other concerns, ma'am, as to the items identified in this notice?
Until I'm able to open them and see them, no, I do not.
Sure. Okay. State, anything else we need to talk about with regard to that issue?
Not in regards to that issue.
Okay. All right. So
that, and they said she has.
Mr. Lane, I'm going to ask that you take possession of that jump drive that was tendered to you in court this morning.
So the Hoojamawatsit guy here, the prison break guy, is going to take possession of the thumb drive and things, and we can only hope that Johnny Cochran takes possession of her.
And you advise the court that you're going to be meeting with Ms. Boone tomorrow. Is that correct? About approximately what time are you going to be meeting with her? If you know?
9 a.m.
Okay. All right.
We don't know what recordings are in evidence. It's on their list. There's a bunch there. I mean, sure, the one where she, in the one that she incriminates herself, I've seen her incriminate herself in 3 different ones. So I'm not sure which one you're talking about. But oh yeah, they're all going to be in there, plus everything else.
Have had the opportunity to have further conversations with Major Muhammad at the jail, including conversations regarding the physical documents. Ma'am, are you still requesting hard copies of the documents?
I am.
Okay. The jail has advised me that they've had conversations with you related to any other property or legal documents that you may need. Have you ever advised the jail that you have everything that you need and don't need anything else?
No, one of the sergeants came and spoke to me yesterday, miscommunication of some sort, where I explained to her what I'm trying to do with purging my property in the property department so I can anticipate those discovery hard copies.
Was that Tracy Hall?
No, that was Hall. Her last name is Hall.
So it was Hall, H-A-L-L, correct?
Yes.
Okay.
But someone sent her to me to see me, so I just don't know who that was.
Who was it you communicated with yesterday regarding your personal effects that may have been in a property locker?
Miss Hall.
Okay, all right, thank you. Do you know Miss Hall's first name?
I don't know any
Daryl?
of the officers.
Okay.
were.
All right. So in conversations with Major Muhammad, they are going to be able to accommodate you having your paper copies. So Mr. Lane, I know that you took custody of those and have had them. So tomorrow, when you meet Ms. Boone at approximately 9 a.m., you will meet Mr. Muhammad as well. Well, let me ask this. Are you able to go to the jail today?
I can.
Okay, so I know for a fact that Major Muhammad is available today, and he may be expecting you to arrive today. If you are able to provide to him the banker's boxes that were identified as A and B and that jump drive, and then provide the court with a notice as to when and what time and that to whom you gave it should be Major Muhammad, those items, so we can file it in the court file. And those will then be, the digital evidence will then be provided with the laptop in accordance with the protocol that we've gone over previously. And Major Muhammad will make sure that Ms. Boone has access to the hard copies. So after conferring, well, let me ask this. State, do you have any other position with regard to the motion that was set to be heard today, the defendant's motion regarding seeking for hard copies?
No, Your Honor.
Okay, so for the record then, that motion will be granted. The motion for defendant to lawfully receive, review, utilize the original hard copy discovery, 2 boxes A and B, submitted to the court by former attorneys on June 28, 2024 for preparation of trial in her criminal case. As ordered, Mr. Lane will deliver those to the jail today and seek to have them delivered to Major Malik Muhammad, along with the
This is
digital,
Sarah Boone to Major Muhammad.
the USB drive with the digital evidence.
Can you hear me, Major?
Mr. Lane, the deposition transcripts of detectives
There's
Chelsea
nothing
Hopsall
I
and Scott
can
Lowen
do.
were purportedly sent to you on August 1st. Did you receive those from Ms. Cashman?
Yes.
Okay, were they a part of the 2 USB drives that we addressed on August 5? You had the smaller one, which was everything you digitized from the 2 boxes, and then you had the larger one of other materials that you had been given previously.
No, but I do have a drive that I can put them on and make sure they get to the jail today.
Okay, if you could make sure, sir, that when you drop off the other 2 things, digital copies, I know Ms. Boone has identified that she has the physical copies, but I'd like to give her digital copies just in case. State, do you have any questions with regard to the court's directive to Mr. Lane regarding the hard copies, depositions of the detectives, or the digital evidence the state may seek to admit in trial?
No, Your Honor.
All right. Ma'am, do you have any questions for Mr. Lane regarding those 3 items?
No.
Okay. Can Mr. Lane be released?
Yes.
Okay. If you want to, can he be released, ma'am?
What?
I guess I'll see you at 9.
Okay. Sir, if you could endeavor to do that today, I would greatly appreciate
Sarah
it.
Boone,
All right. Thank you. very much, sir.
unburdened by what has been.
All right. The next matter this morning is the defendant's motion for defendant's reasonable freedom and movement. by
Okay, this is the one I'm
allowing
interested in.
unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom that was hand filed at the court on August 5, 2024. Court has had the opportunity to review that.
So this is her motion to be able to get out of the handcuffs, out of the leg shackles, and be allowed to walk around, to be able to stalk the courtroom like a good lawyer, like a good defense lawyer. That's what she's looking for. She wants her. I don't want your freedom. So the judge is going to tell us what's up.
That motion and the law regarding restraints. State, do you have any positions at this time with regard to the defense's motion?
Your Honor, in speaking with courtroom security, we would oppose the motion. And
They want to keep her chained.
Gavin Lowton available to supplement this court's knowledge on the issue.
Okay. So, ma'am, we're going to have a hearing on your motion. The state will call the corporal. He will be inquired by the state as to some concerns that they may have, and you'll be given the opportunity to ask him questions or cross-examine him after the state's concluded.
What if she
asking any
attacks us with a
questions.
suitcase, Your
Do
Honor?
you have any questions about that process?
Is that today?
That will be happening right now. Yes,
Right
ma'am.
now.
Okay.
Do you have any questions about that process?
I don't.
Okay, all right, let's go ahead and call your witness. State.
State will call Gavin Logan.
Do you swear or affirm that the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God?
All right, I gotta
Sir, good morning. Can you
small
state and
myself.
spell your name for the record for me?
Gavin Alton, Gavin LWTAN.
All right, thank you. State, you may proceed.
Good morning, sir.
Good morning.
And what is it that you do for a living?
I work for the Orange County Sheriff's Office as a deputy sheriff.
And to what area of the sheriff's office are you assigned?
Court security.
And how long have you?
Hey, dude, see this thing over here? See this like long thing with the little knob at the end? Point that at your mouth. You're a corrections officer. You should be used to pointing the knob at your mouth. Do it so we can hear what you're saying, bruh. Come on, point the long shaft and knob right at your mouth like you're used to.
You work that assignment?
That was mean.
4 or 5 years now.
And tell us, what are some of your duties within that assignment?
I supervise the deputies in 2 felony courtrooms and 1 civil courtroom.
And are you familiar with the defendant in this particular case?
Just through research that I've done on her, I don't have any personal knowledge.
The research you've done on her, you research your prisoners? Is that when you're not counting your chins, you just research the prisoners?
And what, in regards to that research into the defendant, what is your position as the head of security regarding her request to be free from shackles?
I do not believe she should be free of shackles.
And why is it that you have come to that conclusion?
Based on her current charge of second degree murder, she also has previous domestic arrest for battery.
Her boyfriend is killed enough. He's not going to be killed again. And I know she's going to have 2 boxes of evidence with her there. She might try to attack you with the boxes of evidence or make a break. Come on.
By strangulation. She has 3 separate incidents at the jail for non-compliance, where she was told to attend her court hearings or scheduled court hearings, and she refused to do so.
Oh, so he wants to keep her shackled because she refused to go to a court hearing? Huh? No, she is going to, I haven't seen this, but without a doubt, she is going to be unhandcuffed at the very least because of the presumption of innocence. If you're a juror and you see that the person representing themselves is in handcuffs, that is way, way prejudicial. And it puts in your mind, well, my God, they're in handcuffs. She's probably guilty of something. She's a danger. The handcuffs are coming off. And I would assume the shackles are coming off too. We'll have to see how, and if any of you have seen it, no spoilers, please. Yeah. John Wick, he had only a fucking pencil, Jeff. he killed him with a pencil. A fucking pencil. Anyway, sorry.
And then even when the corrections officers told her she...
Okay, that would be funny if he just like went Sarah Wick and just like took everybody in the courtroom out all at once with like a pencil and a laptop. Okay, that would actually be really funny. It would be horrific, but I would be laughing the entire time.
The court, she still refused to attend those hearings. Those kind of, when you combine all that, to me, it shows a propensity for violence and not wanting to follow lawful commands and orders.
Not wanting to go to a court hearing shows a propensity for violence? I'll intercourse right off.
Of law enforcement personnel.
What accommodations can be made in order to keep concealed the fact that she is shackled or restrained during trial?
So when the defendant is here, she would just be in leg restraints. She wouldn't have the belly chains. She wouldn't have handcuffs on. We've modified the leg restraints by wrapping tape around the chains So even if she's to make motion or movement, it wouldn't make noise to alert the jury as to that she's got restraints on.
She would probably walk pretty funny to the podium, though. She would probably walk up to the lectern, really funny to be. What is all that tape between her leg? Well, that was okay. That was a weird way of putting that, wasn't it? I don't even know how to say that other than what is with the long tape between her legs.
She would be brought in and sat at the defense table prior to the jury coming in and being seated, so they wouldn't see her walk in with restraints on. And there's a panel in front of the defense table that prevents the jury from seeing that she's got leg restraints on.
Your Honor, I don't believe I have any further questions at this time.
Thank you. Ma'am, do you have any questions for Officer Logan?
Yeah, what I would laugh if her question is, why are you such a dick? Because this guy's just being a dick, really.
I do.
Go ahead.
First off, in your, in quotes, research that you've done on me, the domestic violence.
See, look at that. She has to, because she has a belt, a chain belt around her waist, and she's handcuffed to her chained belt. She has to say, in quotes, she's not even free to make air quotes. Free Sarah Boone, free Sarah Boone, free Sarah Boone. Her rights are being impinged. She doesn't have the freedom to exercise her rights to make air quotes in court. She has to actually use the words in quotes. This is injustice. And if this is your first time viewing the channel, I'm joking.
Quotes research that you've done on me.
In quotes.
The domestic violence case that I was charged with, the felony with strangulation, was dropped. I don't know if you were aware of that in your research. Yes, so I was never charged with that. Also, what 3 hearings is it that I supposedly missed on what dates?
I have those here.
Oh, good question.
I've never missed a court date. In the almost 5 years that I've been here, I've never argued, I've never hesitated.
Objects to the form of the question, Your Honor.
I'm going to sustain the objection. Ma'am, you have to ask one fact per question.
She's actually asking very good questions. She asked a compound question, which is a lot of different questions all in one question. She needs to break it up. Like you said, one fact per question. Just break your questions down, Sarah. You're actually doing really, really good here. See, if this ends up being a shit show of a trial, it's not going to be a shit show of a trial like Darrell Brooks. Darrell Brooks, he just refused to participate in the proceedings. On the other hand, she is going to participate a lot. And, you know, where Brooks would get like maybe one sustained objection out of 1,000 objections, she could probably get about a 7 out of 10, 6 out of 10. She's actually asking very good questions. She's doing a pretty damn admirable job. I'm liking this so far. This is good.
Okay.
I am prepared to give her the dates. Okay. On September 15, 2023, that was one of the times you refused to attend. October 16, 2023, and January 28, 2021.
Jesus.
And do you know what those were specifically for?
For court attendance.
For court attendance.
For that day.
For a hearing or pretrial or withdrawal?
I don't know. This is just information from the jail where the corrections officer said you refused to attend your hearings.
So is that on record that I have supposedly refused these 3 dates to appear in
At
court?
the jail, yes.
Who is your contact, please? I've never missed a date.
This is the database that I got this information from.
She's actually kind of making him look stupid. I like this. He doesn't have any direct knowledge. He has to look things up. He doesn't know. He's just going off a record that he had. He's just parroting shit that he read or that he was told. He has no knowledge of this. This is great. Sarah. Man, if I was in her cell and it was like the bars and I had a tin cup, I'd be running that tin cup along the bars, praising Sarah Boone and her handling of this guy. She's making him look kind of dumb. I like this.
Do you know when it was last updated?
I don't know.
Do you know how I have never missed a court date to the present date? I don't know specifically what these 3 dates are for. In order for me to have supposedly denied going. Do you know the name of the officers for each one? You do?
Yes.
Please.
And she's asking, please.
September 15th, 2023, it is Corrections Officer Portia Hines.
Could you spell her last name, please?
Hines.
And you said the date was 9/15/23?
Correct.
Okay.
All right.
And if you would like, I can read her comments in her report.
Sure.
At approximately midnight, I informed inmate Boone, Sarah, that she was scheduled to appear in court today. Inmate Boone stated she did not want to attend court. I advised her that her absence could result in being held in contempt of court. Inmate Boone stated she understood and continued in her decision to refuse. Corporal L. Cameron was notified. This report is being generated for informational purposes.
But it doesn't say what it was that I supposedly refused.
To attend court. It doesn't say specifically what your hearing is for.
Okay.
Ask the next question, Sarah.
Second one.
Sarah, no, Sarah, you lost an opportunity here. Let's break this bullshit down. Let's break this bullshit down here. All right. So we got to go back here to midnight, which she should be asleep, but I guess perhaps they rousted her out of a sleep. I'm just going to assume, but this is some bullshit here for a reason. And she missed an important question. She missed the next question she should have asked, because he's saying she refused to attend. She's saying, I never missed a trial. I never missed a hearing. I never missed a court date in 5 years. Let's break this down.
Okay.
And if you would like, I can read her comments in her report.
Sure.
At approximately midnight, I informed inmate Boone, Sarah, that she was scheduled to appear in court today.
Okay, so at midnight, she's told that she has to appear in court today. And going on what she's previously said, they roused them out of their racks at 3 a.m. to get them all ready to go and put them on the bus and take them to court and do all that other stuff. So she's told Sarah Boone, you've got a hearing this morning. That's the launching pad for this BS here.
Inmate Boone stated she did not want to attend court. I advised her that her absence.
She said she did not want to attend court. She just said, I don't want to go to court. And I could see being crabby and saying that. There is nothing wrong with saying that. And then very helpfully, Portia here says, if you don't go to court, it can be contempt.
Held in contempt of court. Inmate Boone stated she understood and continued.
She says, I understand. And apparently continued her saying that, I don't want to go to court. Being obstreperous and saying she doesn't want to go to court. But
in her decision to refuse. Corporal L. Cameron was notified. This report is being generated for.
That's the end of the report. The end of the report was the interaction at midnight. The next question Sarah should have asked was, did I or did I not attend that hearing? That should have been her question. Because then if dumbass here has to say, okay, yeah, you did attend the hearing, the wind is taken completely out of this BS sales. Exactly, Ms. K. Griff, did she show up or not? Is it actual refusal, though? Exactly. Those are the questions. She should have asked that question. That would have been the next question. Because both can be true. At midnight, she could just be bitchy and going, I don't want to go to court. Yeah. But then she does her job. She gets up without complaint, without resistance, without making a stink at 3 a.m. and shuffles her ass off to court. So he's trying to rely on this report that was generated 3 hours before she was even supposed to be up and a full 8 hours, at least 8 or 9 hours before the hearing was supposed to start, to say that she was refusing to go to court. That's some BS right there. That's some BS there, Sheriff. But Sarah, you dropped the ball. You didn't ask that question. And then she just, no, apparently not. Been there, done that. We just, she didn't review. We don't know because she didn't ask the question, but she is saying she was at every hearing. She should have asked that question. And Sarah Wick took them all out with just a suitcase. Thank you so very much, Adara. And earlier on, Daryl Smith also noted this. Wouldn't the court have a record of that missed appearance? Exactly. She's saying she didn't miss. And this is some BS. She's just close to catching him out on it.
For informational purposes.
But it doesn't say what it was that I supposedly refused.
To attend court. It doesn't say specifically what your hearing is for.
Okay.
She isn't a very skilled attorney.
Second one.
But she's not doing poorly. She's law student level. She's law student level with her questioning. I'll give her that. Kudos and props to her, at least in that regard. She's law student level with her questioning.
It'll be Officer Christy Green.
And what is this date for?
I'm sorry, what's that?
Which date is it that you're referencing?
That's going to be October 16, 2023.
Okay, and I'm sorry, the name?
Green, G-R-E-E-N-E.
Green.
And what's the first initial, please?
K.
G-R-E-E-N-E.
Yes.
10/16/23.
Yes.
Okay.
And the third one is January 28, 2021.
Ask the question, Sarah.
Jasmine Scribner. S-C-R-I-B-N-E-R.
What are the comments, please, for Green?
At approximately 0300 hours, I advised inmate Boone, Sarah, that she was on schedule to attend downtown court. Inmate Boone stated she did not want to attend court. I informed inmate Boone that if she fails to attend, she could be held in contempt of court. Inmate Boone acknowledged she understood and continued with the decision to refuse to attend court. Corporal Ward at the Booking and Release Center, transport officer, was notified. All proper notations were made in the IMS.
Okay.
Ask the question, Sarah. Or maybe she is playing some 4D chess here, people. We've got 416 people here right now watching this. She might be playing 4D chess. She might be way better and way smarter than we're giving her credit for. She may know that she didn't attend those hearings. She may know she didn't, and she's just trying to undermine him based on those reports. She might be smart enough to know not to ask whether or not she attended those hearings. Ooh, 4D chess Sarah. Ollie 90211 says, she's an idiot. Yeah, I'm trying here. I'm just trying. I'm trying to give her the benefit of the doubt. Nah, she's just an idiot. Big brain Sarah. Big Sarah. Big brain Sarah.
And January 28th?
Approximately 0334 hours, inmate Boone, Sarah, was advised she has downtown court and to start getting ready. Inmate Boone stated she did not want to attend court. I informed inmate Boone that she could be charged with contempt of court. Inmate Boone still refused to attend court. Corporal Hall and the Booking and Release Center transportation officer were notified of this incident. This report is being generated for informational purposes only.
And all of those comments were made on the day of that I supposedly refused.
I don't know when they entered that.
It doesn't state in their IMS, in their program?
It might, but I didn't take that information down.
Okay.
Ooh, so he doesn't know when those reports were filed. Were they filed on the same date? Were they filed early? Were they filed a day before the hearing? Is it all a lie? Sarah is doing good here. Jeff's been fanboying too much. It's weird. Hey, I'm just saying she is doing at least an average job here. This is law school level stuff. She's not doing too bad. But if she actually attended those 3 hearing dates, she should have asked that question. Although I refused to attend the hearing, although I said I didn't, she didn't refuse. In all of these, notice there was never a refusal. There was never this, I'm not going, so F you. She said, I don't want to go. There was never an actual refusal in those reports. If she actually attended, she should have asked that. Did I attend or did I not attend? And if she did attend, then all of this is just extraneous BS.
Okay. So I'm trying to figure out I know all 3 corporals and the sergeant, so I've never refused court. There's no reason for me to want to refuse court.
I'm going to object this to ask and answer.
I'm going to sustain the objection.
So the domestic violence, the original, was dropped. I was never charged with that.
Object as to relevance, Your Honor.
Overruled.
Ha! She won one. She won one, even though the objection should not have been relevance. The objection should have been to the form of the question. She made a statement. She didn't ask a question. -1 for the prosecutor, +2 for Sarah. She made a statement, not a question, and the objection was overruled.
You can answer the question, sir.
Okay. It was dropped. You were charged and arrested. I don't know why the state dropped it. It could be because both parties, based on the report that I read, did not want to cooperate. So they probably didn't have information to go forward with the charges. That does not mean that you didn't commit the act.
No, Leo. No, Sharif. No, Omar Sharif. You don't get to do that. Now, remember, this is all about whether or not she should be able to participate without handcuffs and shackles. And he said, no, one of the reasons she needs to be kept in shackles was because of this prior domestic violence choking charge. She's like, hey, that was dropped. Well, you may still have done it. You don't get to go there. She was never found guilty. You have to treat it as if that never happened, brah. You can't say maybe she did it, even though they decided to drop the charges. Dude, this sheriff is so reaching. Shame on you, Sharif.
They didn't have a case that they could win.
Omar
What is your
Sharif, one of the
definition
greatest actors ever to
probably
live.
did not cooperate. Was it a fact or you're just guessing?
Your Honor, I'm going to object to the question.
Objection sustained.
Compound, maybe?
Both of the charges were dropped for Mr. Torres and for myself was because we did cooperate and there was not enough information. And we received documentation.
Make it a
from
question.
both of us for the
Make it a
reasons why
question.
it was dropped.
Say correct.
Your Honor, I'm going to object this to the form of the question. It's not a question, it's a statement.
Sustained.
Make it a question, Sarah. Make it a question.
Forgive me because I don't know what I'm doing. I'm trying to provide my information for what it is that I'm being accused of.
Yes.
I don't know if I'm doing it the wrong way, apparently.
Ask a
So-
question. Ask a question. Was I or was I not charged with that? What was, ask a question. One fact, one question.
So I don't know I don't know the protocol for this. I'm just trying to answer my accusations.
I understand
But-
your position.
But
I cannot tell you what to do. I cannot provide you any legal advice.
Okay, I'm just stating to the court that I'm doing my best with being uneducated in this situation.
If only you didn't run off 8 lawyers.
That is for the non-compliance, I need to speak to the corporals and the sergeant in order for that to be remedied. And then what about, do you need the documentation for the domestic charge that I was not charged with and it was dropped cooperatively?
I do know that the charges were dropped. I'm just saying that isn't your history.
I understand, but I was never charged with it, correct?
You were charged with it. It was dropped. The charges were dropped.
But it is not on my record.
You were not convicted. You're looking for convicted, Sarah. I was never convicted of this. They were dropped. I was never convicted. Lots of innocent people are charged with things and the charges are later dropped. I was never convicted of this. I never went to trial for this, correct? One of those questions, Sarah.
Right.
But the charge for the domestic violence is not on my record.
No, you were never convicted.
To ask and answer, Your Honor.
Overruled. You were never convicted of the domestic battery charge. But
So therefore, it should not be used against me in this motion. Correct? Correct.
The case was dropped.
Yes.
For the 3 supposed non-compliance that I have, I know that 2 of the officers are no longer with the Department of Corrections, Orange County Corrections Department. So I will need to speak to their supervisors in order for me to have, I guess.
Yes, you're on the right track, Sarah. You're on the right track. Demand that they be brought into court to testify as to directly what they heard and saw her say. You're on the right track, Sarah. You were born this way. You're on the right track, baby. She is doing remarkably not horrible.
This remedy, is it a...
Your Honor, I'm going to object to the form of the question. This is a statement.
Ask a question, Sarah.
Objection is sustained.
Ask a question. She's feeling stressed.
I guess I will provide information to you for the non-compliance occurrences that I'm being charged with.
Your Honor, again, I'm going to object as to that's not a question, it's a statement.
The objection is sustained.
I know this is a lame question, but what does sustained mean?
Oh, God. No, Sarah. No, you can't ask what does sustained mean. Oh, no. All right. Says Miss K. Griffin rings exactly. Like, chat, no matter, there ain't no way for me to spin that in her favor. Oh, no. Well, yeah, okay, yeah, at least she recognizes it's a lame question. Oh, my God. Ali 90211 on the repeat. She's an idiot. Okay, this time I can't argue with you. This time you are demonstrably correct. And Danielle, what's up, Big D? Danielle just says, oh dear. Oh no. At least it's a question. You're right. At least it is a question. Oh no. What does sustained mean? Perhaps when you were writing your 58-page letter quoting bits and pieces of Bouvier's Law Dictionary 2012 edition, you should have looked up sustained. Just saying. You've heard it once or twice in court over the past 5 frickin' years. Perhaps you should have perhaps you should have looked that up. Now, Sarah, there's not just one. There's multiple booklets out there that they're not big books. They're just little thin pamphlet-y sort of books that have essentially all of the objections you can make, all of the objections and responses to those objections. For the love of God, Sarah, get a copy of one of those books or pamphlets somehow from the law library or somewhere. Get a copy of lists of objections that can be made, the grounds for those objections, and how to respond to such objections. Oh no, what does sustained mean? Oh God. I can't. She knew what overruled was, yeah. I've just lost my ability to spin things in her favor right now. Yikes. Duncan, Idaho, all the way from Dune, Duncan, Idaho, with a $5 super chat. And the reason for your sustainment, Your Honor, grounds for sustained. Oh, unfortunately, we might get there. I didn't want to believe it, but we might get there. There needs to be a pro se for dummies. Well, I mean, by definition, pro se is a dummy. That's sort of redundant. All right, rip the Band-Aid off. Oh, the wound gets worse, does it? Oh God.
That means the state's legal basis for you asking that question is
sustained.
Correct, and the court will not permit you to ask that question
Thank you.
in the way that it may be asked.
What do I need to provide to you in order to have that remedied in order for me to be unhandcuffed?
I can't
Your
advise.
Honor, again, I'm going to object as to the form of the question.
Overruled.
Oh, well.
Whatever documentation, but I believe that the decision as to whether or not you'll be in restraints will be made today.
You will.
I understand, but it can be made.
What's that?
The decision in order to be unhandcuffed.
Correct.
Uncuffed.
I suppose if you have documentation
By what has been
that
before.
this was all fabricated, then I wouldn't be able to use this.
Correct, as you telling me about the domestic violence.
Yeah, exactly. Okay, she's back on the right track.
It is still part of your history. I can bring it up.
An incorrect
Right.
part of her history.
But just to clarify and conclude, I was not ever charged
No, you
with
were charged.
that.
You were asked and answered.
Sustained.
You were asked and answered.
Okay, I will, do I provide this information to you?
You can provide it to the state.
Okay.
Ooh, that's an idea, Swamp Bear. Thank you. I like that.
Am I, in your opinion, a flight risk or?
Yeah. No. Don't ask that.
detrimental?
Don't ask that. Do you think I'm he's just, oh man, Sarah, of course he's going to say, why, yes, I think you're a very, very, very good flight risk. You know, the Olympics are on. You could be an Olympic runner. You could make a dash for it. You could get past Officer Friendly and my chins, and you could make a break for it, Sarah. You are a horrible flight. That's what he's going to answer. Come on. Don't serve him softballs.
To the courtroom and am a threat of any type of harm?
Based on what I've researched, I don't know you personally, but based on my research, I don't think it would be appropriate for you not to be in restraint.
And then what was the year, please, for the charge that was dropped with the domestic violence?
It was 2018.
Mr. Medina.
2018?
Correct.
And it is now 2024.
6 years ago. Okay. Oh, she's on the. So you want to use something that I was charged with that was ultimately never convicted of, never went to trial on from 6 years ago to make a determination as to what my behavior is today. You're on the right track, Sarah. Damn it, if only you had a lawyer to ask these questions.
Okay. And you're going solely off of, what, the arrest affidavit?
Yes.
What is it that you're using to conclude due to this occurrence that was dropped, that I would not be able to be unrestrained?
Correct, your arrest history, the information I read, all the research that I've done, that's where I'm basing my conclusion on.
But what specifically from that 2018 charge?
The fact that you were charged with battery by strangulation, which is a violent act, is one of the reasons why I've said that I do not believe it's appropriate for you not to be in restraints.
But it was never proven, correct, because it was dropped?
It was dropped, doesn't mean it didn't happen.
No, you don't get, no, don't say okay. Press him on that. Press him on that doesn't mean it didn't happen shit. I was never convicted. I never went to trial. Correct? Press him on that. Press him on that. Don't just say, okay, don't give in, Sarah. Fight the power. But I'm going to take this little brief respite here. We are just over we're right about at the halfway mark, actually, just a couple of seconds over. So I want to take this to be our little midstream grift here. We currently have 442 viewers, 289 likes. We need 150 of you, up to 160 of you to get down there and hit that like button. Please do that. Let's get this thing going. Excuse me. Let's get this thing going. Let's get this thing out there on YouTube's front page. Let them know there's something exciting and cool happening here. Hit that like button. And if you have not subscribed to the channel, I would be incredibly honored and humbled if you would do me that honor of hitting that subscribe button, hitting the notifications. Do not miss a Sarah Boone update. Do not miss a Karen Reed update. Do not miss a What the Hales update. Clayton Eckert update. Don't miss anything that's coming up. Maritime Mondays, Retro Trial Thursdays, F It Fridays, Unexplained streams. We've got it all. Do not miss it. Subscribe. And if you are subscribed, just double check and make sure you are still subscribed to the channel. Let's get that subscribers up. Let's get those likes up and make sure you take our like and subscribe poll. Currently, the like and subscribe poll is at 432 votes. That means 100 and about 30 of you have cheated. You've taken the poll without actually hitting the like button. Come on, people. Don't do that. Don't be like Sarah. Don't do that. I don't know what that means, but just don't be like Sarah. Sarah Boone, 19% of you said Sarah Boone is smarter than you. 24% of you said Sarah Boone is confused. 24% of you also said Sarah Boone has an airtight alibi. Luggage joke there. And in first place on our like and subscribe poll thus far, Sarah Boone doesn't know what to do. Both of which she's already said she's confused and doesn't know what to do today. So both of those are accurate. And 34% is leading with Sarah Boone doesn't know what to do. All righty. And we are, looks like we're about $88 away from the second goal being unlocked. And thank you to all of you that used the Venmo, the Cash App, the PayPal, the Zelle yesterday to get us up to the third level of achievement. Those are still options if you don't want Sarah Boone and YouTube to take their 1/3 cut. Just keep them coming. All right, let's get on with this. She's starting to go in circles. We need to move it along, Sarah. Move it along. Move it along. Let's go.
I'll be working on the others with the corporals and the sergeant for the supposed non-compliance. Thank you for the dates, the information.
You're welcome.
Ma'am, do you have any other questions?
Do I need to supply anything for the 2018 domestic violence occurrence that you are referencing and applying?
It's already been dropped. I'm just telling you what the history is. So,
And you can still apply it even though it's not been.
correct. It's in your history.
Okay. Thank you for the information.
Stop thanking the evil people for their information.
Any follow-ups, Dave?
No, Your Honor.
Thank you, sir. Anything else, Dave?
Not from the state.
Okay.
He's going to take the cuffs off. He has to. I think he's also going to take the shackles off. So the cuffs, this chain belt, unless it's a fashion statement, is going to come off. The shackles, I believe, are going to come off as well, just for you know, to avoid prejudicing her in front of the jury.
I see Deputy Barnett here. Could you come up, sir?
Wow. Officer Lumpy.
He swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Oh, he's not going to make his ruling yet. We have to hear from Officer Lumpy.
Sir, good afternoon, or good morning, rather. Can you state your full name and date of birth for the record for me?
My name is Chad Ornette.
And not your date of birth. Sorry. Could you spell your name for the
D-B-A-R-N-E-T-T.
And what are your duties and responsibilities here at the Orange County Courthouse?
I'm a deputy sheriff at the Orange County Courthouse. I work in courtrooms, I supervise squads, and I'm also in charge of training inside the courthouse.
Okay. Is there any training that's addressed with regard to other security measures other than shackles that may be provided for defendants?
Yes, we have an item called the stun cuff that is also used in the courtroom.
Okay, could you step us through what a stun cuff is?
Yes.
Stun cuff is a electronic device that's wireless. It's it's box secured to the leg. It has 50,000 volts, and it's able to be remotely sparked from a distance.
How is it fixed or placed on a person?
It's dual strapped along the calf of either leg. It can be hidden in the pants, and gives the ability to people to walk around.
And who is in charge of operating that device?
It'll be an assigned officer that's been trained in the device.
And step us through the operation of how that device is utilized or operated by that officer.
Now this is interesting. The Bluetooth taser. This is interesting. This is how they Jedi mind tricked Darrell Brooks, or Darrell Brooks, depending how you want to pronounce his name. Yes, can we get Darrell Brooks to come in for a demonstration? This is how they Jedi mind tricked Darrell Brooks. They told him he had stun cuffs on, but he never did. They never placed them on him, but for some reason, I don't know if they told him he did. For some reason, he believed he had stun cuffs on, but they never did it to him. Now they're actually proposing stun cuffs for her on this. So this is something we didn't get in the Darrell Brooks trial. We're going to get an explanation as to exactly how, as someone just referred to it, the Bluetooth taser chaos coordinator, and we're going to get some indication as to how the Bluetooth taser actually works. Set cuffs for stun, Kirk out. Is she violent? Well, that's she allegedly murdered her boyfriend, and that's what the last sheriff was arguing. She was charged with attempted strangulation 6 years ago. So, all right, let's find out how it works. Electrified Sarah, the electric boogaloo 2.0.
Officer.
The officer will show the device to the subject or the inmate or the defendant. It will be secured with 2 straps on the leg. There is a waiver to be signed prior to being used, explaining when it would be used, if it was needed to be used during court, violence, attempt to escape, any actions that lead to that level of to use the device. It's a 2-step process, so there is no way for it to accidentally be set off. It has to be hit 2 separate buttons so there's no accidents.
So it's like a Claymore mine. They have to click it a few times to get it to go off. So just one bump won't nuke her. They have to click it twice. It's the Claymore mine of courts. And I don't know if I'd want this guy doing it. This guy looks like he would just be like, I'm click. Zzz. So that's interesting. They have to sign a waiver to say you agree to be zapped if you do one of these things. Okay. And then if you do one of those things, I guess there's like all right, let's do it. Click, click. Zzz, zzz, zzz. This is cool.
If it had to be used, it would cause a shock to the location on the cab.
One of the court officers would have the
most
remote.
likely to fall to the ground, and we could secure and take care of the situation.
Are there any other protocols or standard operating procedures regarding the use of the stun belt? Other than what you've already identified?
Just to follow what I used to have.
So they're like electric garters, it sounds like. Will it look like a Highlander? That would be funny if it's like just like electricity shooting out everywhere and she stands up. There can be only one. All right. That's good. It'll look like Highlander. She just like levitates in the air with electricity shorting out the cars in the parking lot and zapping the lights in the courtroom. That would actually be pretty damn awesome.
Response to resistance policy.
Okay, and can you explain the
Look like a
response to
Highlander.
resistance policy?
We have a level of response to resistance depending on what an individual does to what we would do. So if she was attempt to escape or fight, we would use it to match that level of resistance.
What is the level of resistance whereby which the stun belt would be deployed or utilized?
At this moment, it's at a level 3.
And what is a level 3?
Level 3 would be failing to follow directions and stuff like that. If we asked her to get up and move or not, or follow the lawful order, we could use it. Most likely in the courtroom, we would use it probably at a 4 level. That is pretty much fighting.
No, Jonathan Irwin. The shocker is something completely different. We don't want the shocker to be deployed anywhere near the court.
Attacking another person.
Okay, all right.
Oh,
State,
no.
do you have any questions to Deputy Barnett?
No, sure.
Ma'am, do you have any questions for Deputy Barnett?
I do, please.
Go ahead.
Oh,
Tell me, what is the title of this?
Stun cuff.
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 And you said this was applied on the calf or the ankle?
Yeah, the Achilles tendon area of the leg.
And is this something that does it need extensive preparation, or is it something that can just be put on coming and going from the courtroom?
I'm sorry. I like the AP. You may strike me down, but I'll grow even more powerful. Shut up. Obi-Wan Boone in the courtroom.
We would place it on you before the court starts, and you can take it off as court every time we exit the courtroom. It takes a few moments besides signing the waiver and securing it to you.
That's how they took
And
out
it's a
Achilles.
one-time waiver?
Each day you have to re-sign the waiver.
Okay, so there's no limit to how many times it can be put on and taken off, put on, taken off?
No.
The
And
limit
it's
is
a very
how long
simple-
you're trying.
Very simple process to apply
Yes,
and remove.
yes.
Thank you.
Any follow-up?
Not from mistake. Why?
Sorry.
Sorry.
Would I have my hands free, correct?
Yes, you would have your hands free either way. If you were in a leg iron, your hands would be completely free. The stun cuff, same thing.
And then I would be able to walk?
You will be able to walk with the stun cuff freely, yes.
So hands free and able to walk?
Yes.
Thank you.
Any other follow-up? State.
No, Your Honor.
All right. Can Mr. Barnett or Sergeant Barnett be released?
Yes.
Ma'am, can he be released?
Yes, thank you.
All right, thank you, sir. State, any argument, any further witnesses, evidence, or testimony with regard to the defendant's shackle motion?
No, Your Honor.
Ma'am, do you have any other things that you would like to tell the court with regard to your motion?
I don't understand what Sergeant Burnett was that you all providing me an option?
No. He's providing the court with an option, not you, Sarah, the court. He's explaining the options that are available to the court for the court to make a decision for you. You don't get to make the decision.
There is Florida Supreme Court case law addressing reasonable measures for movement by a defendant in the courtroom.
So that is an option.
It's an option for the court to
Yes.
consider.
Okay. Do I need to supply the information in regards to the supposed 3 non-compliance before that can actually be made an actual option?
I cannot answer that question because that would be me providing you legal advice as to what you could, can, or should do, and I cannot do that.
Would I be able
Trust
to
your
be
feelings, Sarah.
unrestrained with that information?
I think that would come down to the argument of yourself and from the state as to what the court has to consider with regard to your requests and your motion and what the law is in the state of Florida.
If I may make it clear also, I'm simply just asking to be unhandcuffed so I can write and move properly. I'm not trying to maneuver the courtroom and so on and so forth. I simply just am asking to sit here being unhandcuffed so I can write without taking skin off of my wrist and being extremely uncomfortable.
Okay. Ma'am, thank you for that clarification, because when I read your motion, you asked to be unshackled, to have freedom of movement. And I interpreted that as you wanted to move as everybody else may be able to move in this courtroom, as Mr. Cacciatore has moved around, how other persons have moved around. And it wasn't only limited to your hands. I thought it meant to your entire person based on what it is that you were seeking in your motion. So just for the purposes of my own clarification, is your motion only seeking to have your hands not bound so that you can move your hands, but otherwise shackles that may be on your legs would continue to stay there?
Right. I don't currently have shackles, but I don't know what is in regard.
Yeah, you would in the normal court proceedings, you'd be shackled. Mary Jane, really not Sarah, says, I hate that our Twitters, I assume you mean Super Chat, have to go through YouTube. No, they don't. We have all the links down there. We have Zelle, we have Cash App, we have Venmo, we have PayPal. We got it all. We have all the alternatives that YouTube doesn't get their 1/3 sticky fingers into.
Regards to trial procedure, and in regards for you not having the clarification of me just wanting to be unhandcuffed, is it my responsibility, or I don't know if you can answer this, but you don't ask questions, which is what got me in this predicament from the get-go of having no counsel, because no questions were ever asked to me, just for the majority of my motions and letters and so on that I have supplied the court for more information to try to intervene and help. It's just gotten me into hotter water and no counsel and still restrained. So is it something that I need to specifically clarify going forward, or is it something that you have the ability to ask me questions so you have a better understanding?
Generally, I don't know that I can answer that question because it may call for me providing you legal advice. If I'm asking questions, it's because I'm trying to clarify things from my understanding. I cannot ask questions on your behalf. I cannot ask questions for you. I cannot assist you in any process, be it this hearing or at trial.
Right.
I promise.
Yes, I understand. I wasn't asking for assistance. I was just trying to understand by you not asking questions in regards to my motion about being unhandcuffed and unshackled simply meant just my handcuffs.
Zeeb, what's up?
Ma'am, I reviewed your motion to be unshackled, unhandcuffed, and allowed reasonable freedom to movement and functioning.
Oh, no, Jane, I would never solicit them that way. I'm just saying I have options. People can freely, I prefer super chats. I would never solicit things that way. That would just be wrong.
And accordingly, equally, and comfortably while utilizing the courtroom. All normal movement of the defendant's hands is as a whole freely, properly, successfully accomplish any task that is needed. Asking to be unshackled and unhandcuffed. The defendant
unburdened by what
his equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court, which will greatly enhance the productivity and progress for the defendant and the completion of her defense in her criminal case in preparation for trial. Your wherefore clause specifically asks to be unshackled, unhandcuffed, and allowed reasonably freedom in movement to function equally, accordingly, and comfortably in the courtroom. I took that as you wanted to move around. You did not want to be shackled, which would be your legs as well, and you did not want to have handcuffs. If you're telling me now that
do not show this close up. That is, nobody wants to see this. Nobody. Stop.
Is your hands to be free. That's respectfully not what your motion says over and over and over again, as I've just read. So if you would like to clarify for me now at this time, you can, as to what it is that you're asking of me.
Yes. Handcuffed. I would like to have these handcuffs removed from my wrists.
Okay.
In regards to the unshackled, I know at some point I would have to maneuver, I'm guessing, in the courtroom for trial. So I didn't want to have to wait last moment to have to do another motion to be unshackled if that's what my option is, because I don't know. So I was just trying to be transparent prior so you would know what it was that I was hopefully expecting. But first,
Go ahead.
it's just handcuffs means unhandcuffed. And if for trial I have to be shackled, to be unshackled.
Okay, and when you say unshackled, what do you mean by that? Just so that we're all in the same field.
Shackled, as far as my understanding is from being shackled, means that I have this along with my waist, along with my ankles. So unhandcuffed is simply for the hands and the wrists, and then
Sarah, I got to give her credit there. By shackled, I mean shackled. I got to give her credit. That was a snarky, unintentionally snarky, but accurate answer. Shackled means shackled.
unshackled would be for my ankles and for the feet.
And is that what you were seeking for trial purposes?
I didn't know if I was going to be shackled or not. So that, again, that was why I was trying to be transparent and up forward by doing so now, to make the court aware that that would be a request of mine at the time.
Okay, all right. So you would be seeking to be unshackled, no leg restraints, no arm restraints at trial, right?
Please.
Okay.
Yes.
Would you also be asking of the court to move around the courtroom when trial would take place?
I'm not sure if this is considered legal advice, but I don't know. I know from seeing other trials, the state and the defense, they maneuver the courtroom in front of the jury, so on and so forth, and they hand things back and forth. I would have to have other movement other than me sitting here. So yes, I would have very limited, reasonable movement in the courtroom for trial.
Okay.
Yes.
Is there anything else, ma'am, that you would like to tell me with regard to what you're seeking in your motion to be hands-free, for lack of a better word, during any hearings that we may have,
Unshackled
and then
by
to
what
be
has been.
hands-free, unshackled with your legs, and to have movement in the courtroom during the course of the trial? Is there anything else that you'd like to tell me about those requests?
I don't know if you've been able to see my difficulty with just simply trying to take notes. Yes, very much. I would like to be unhandcuffed, just to sit here and be in attendance of my hearings, conferences, whatever it is. For the trial, when the time comes for any limited movement that I would have, the stun cuff, I would sign the waiver now. Just whatever it is that I can do in order to enable myself to be able to have the same comfortable atmosphere and movement and equal opportunities just as everyone else.
Thank
He's
you.
an equal opportunity murderer. Jill Ams with a $10 super chat. Thank you so much. I know I'm making YouTube richer, which you should, because they're providing an awesome, awesome platform for me to entertain you and hopefully you to be entertained. I know I'm making YouTube richer, but I love Super Hat. Hey, this is my, obviously you see, that's the thing. You can tell like the real cowboys from just the poser wannabes. You wear straw hats in the summer because like the fur hats, the felt hats, like the rabbit, the beaver pelts, they're hot AF. You don't wear them in the summer. You wear the straw hats, especially ones with these nice little vents that allow your head to breathe. So if you see anybody in the middle of summer wearing these big ass like fur and felt hats, posers.
Anything else you'd like to tell me, ma'am?
No, Your Honor.
Okay. State any argument.
Your Honor, you've heard the Sheriff's Office's position. They're in charge of courtroom security. They presented basically their position is she should not be unshackled, but you've also heard from Deputy Barnett who explained the options that are available to the court. Our position is if you do not allow her freedom of movement with the stun cuff, then today is probably the best day to start talking about the logistics of how we're going to do this trial so it does not create the inference that she is an inmate. Does that mean the state will be sitting at counsel table to question witnesses? How are we going to go about getting back and forth to the clerk and to the witness to present exhibits if she is not going to be able to do the same with shackles? So we just want to bring everything to the court's attention so we can get it all settled today.
I agree, which was the purpose of why we wanted to set it for today, to address all those circumstances and again, think ahead. Ma'am, do you have any closing remarks or arguments that you'd like to make to the court about your desires to be unhandcuffed, unshackled, and or utilize the stun cuff?
I believe that it is unfair that you, number one, want me to represent myself, and then number two, you would like for me to represent myself while being handcuffed.
No.
To be able to progressively and actively participate properly in the same as others with just simply being able to write notes. At some point, I'm sure I will be bringing things with me to court that I need to reach for, to open, to pass normal functions in a body as a whole.
She wants to pass another normal bodily functions. With
the same equal level as anyone in the courtroom would have in order for myself to be able to do the same and function fairly and appropriately. I don't know if this is legal advice or not, but in a trial, are you able to tell me, are defendants shackled? Or is this something that I don't even need to worry about because they're not even shackled?
Typically, ma'am, the defendants have leg shackles that, as Deputy already identified. Deputy
Now, this is an interesting thing. He's correct that normally the defendants won't have handcuffs. They'll have leg shackles on. But this is a special situation because she is acting as her own lawyer. She will be cross-examining witnesses and stuff, and rather than sitting, she'll be at the lectern asking the questions, I presume. In which case, she'll be walking around, and the jury would still see her shuffling in leg irons to the lectern. So, I completely agree with Sarah in this case. She needs to be unshackled so that there is no appearance that she's an inmate. There's no prejudice that she's been arrested and she's so dangerous she has to be shackled in court. I'm voting for stun cuffs because that would leave her hands and her legs free, and she would just get zzzt if she misbehaves. So, all right, I think that's where the judge is going to go with this.
And Blowton identified they're wrapped so that they're muffled so that they don't
but they're
jangle or bring any noise attention.
They're wrapped, but they're still visible if she moves around.
This table would prohibit the jury from seeing those. Their hands are free, but the legs are in restraints.
Thank you. Yes, I very much would like to be unhandcuffed just to simply take notes and function normally and equally. Just for hearings and so on and so forth, which we have a lot scheduled futuristically. And then when trial comes about, either way with trial and or hearings, the stun cuff, I am readily awaiting for that to be an option and to apply as soon as possible. Whatever it is and however it is that I need to, just to at least just have these removed.
Okay.
Mm-hmm. And Duncan Ido says, Jeff, have you ever heard of the state requesting the defendant be unshackled so as not to elicit sympathy? No, the state normally doesn't do that. That would be the defense, but once it's made, I mean, then you get this kind of argument and we kind of end up at the stun cuffs because, normally leg shackles would be sufficient because the defendant would just be sitting at the table the entire time, not getting up and walking around during the trial. But she has to conduct the cross-examination, presumably from the lectern, like the other lawyers will. So yeah, that would be. The prosecution wants them to be in shackles and handcuffs, but any advantage they can get, they'll take. And talking about my cowboy poser, Kurt would fall within the description of posers given by Legal Vices. He's not a cowboy. He lives in Texas, so he has to have part of the Texas uniform. He should get a nice straw hat. Kurt, I suggest that Kurt find a good straw hat manufacturer and get one because they're cool. Not like, hey, cool. Like they're not hot and steamy like full on hats are. But yeah, Kurt has never made any statements to the effect he is a cowboy. So he's like in a different playing field. But he does need a straw hat. Encourage him to get a straw hat. His head will thank him for it. Oh, we already read that. Thank you very much, Duncan, Idaho.
Got it. Any closing remarks, Mr. J?
No, Aaron, just address all the concerns, which is the court's plan.
Got it. All right. Thank you very much. I think the Florida Supreme Court has given us the guidance specifically for a case just like this in Weaver versus State, 894 Southern 2nd, 178 by the Florida Supreme Court in 2004. In that case, there was a pro se defendant who was representing themselves who had been charged with first-degree murder. And there was no prior history of violent courtroom outbursts. The defendant in that case was representing themselves, and there was some concerns as to being allowed to move around the courtroom during trial may present some safety hazards. The court identified as there would be
definitely helps.
Potential sidebars, access to witnesses,
especially
evidence,
with event
jurors, etc. And that in that case, Weaver's pro se status meant that he would be moving about the courtroom in close proximity to the judge, jurors, prosecutors, witnesses, and potential firearm evidence. This closer proximity to various trial participants arguably raises greater safety concerns than the defendant who is represented by counsel and has no legitimate reason to wander beyond the defense table. Given those circumstances in which a defendant is charged with first-degree murder who is representing himself and moving about the courtroom in close proximity to trial exhibits, especially adverse witnesses, the trial court did not abuse its discretion, even though Weaver had no prior history of violent courtroom behavior. In the Weaver case, the Florida Supreme Court found that the trial court's utilization of a stun belt was not so prejudicial when measured against the other alternative forms of restraint, and whether those alternatives are less prejudicial or viable. There was virtually no alternative to a stun gun, given the visibility of other restraints and the security concerns posed by Weaver's pro se status in that case. It is clear as a matter of Florida law that a criminal defendant's right to be free of physical restraints is not absolute, and that under the circumstances in the Weaver case, the decision to employ a stun belt constitutes a rational exercise of the trial court's discretion that was reasonably necessary to ensure order and safety in the courtroom, especially in light of the defendant's pro se status. In that case, we had a firearm. It was first-degree murder. Here we have second-degree murder. The incidents identified by Officer Lotan as to not...
That sounds like a bad science fiction character. I am Officer Lotan of the... It's like if you're in like a really bad sci-fi movie and you have to think of a really stupid sci-fi name to name one of your characters. I am Officer Lotan. How may I be of assistance?
Clients in jail for purportedly refusing to return to show up at court, and the charge itself. The charge itself has some level of concern because it is a second-degree murder, but I don't see how where we are right now is not on all fours with Weaver, especially coupled with Ms. Boone's acquiescence to utilizing the stun cuff and saying she'd sign the waiver today. She doesn't have to. You'll have to sign the waiver when we get to trial. So unless I hear anything alternatively from the state, the courts would grant the motion that she would be unhandcuffed for any hearing we have moving forward. Instead of her position in the box, we would probably have her seated at counsel's table, unless I hear an objection from the state as to that. We'll address motions first. State, any position with regard to being unshackled and B, being seated at counsel's table for any motions moving forward?
No, we defer to the court and the sheriff's office, who is in charge of security. Our concerns are just making sure that she's given a fair trial and fashioning a remedy that is a fair presentation for the jury to observe.
Okay, perfect. Thank you. All right, so ma'am, the court's going to grant your motion, and then you will be unhandcuffed for every hearing moving forward. And instead of being in the jury box, you'll be seated at counsel's table. Okay?
There you go. Big win for Sarah Boone, representing herself pro se. She gets out of the handcuffs. At least, I think he's going to go with the stun cuffs.
Under leg restraints on, but you'll be hands-free.
Okay.
For the purposes of trial, and of course.
Oh, okay. All right. So during the pre-trial stuff, during these status hearings and other hearings, she'll be sitting over here on the left side at at counsel's table, the defense table, with leg irons. Well, she'll be shackled, but at trial, he's gonna say there will be no shackles, and she will have the stun belt on, or whatever it's called.
With the Florida Supreme Court decision in Weaver, you will be hands-free and you will not be shackled with legs. But the stun cuff, as identified by Sergeant Barnett, will be affixed to you, and you'll have to sign that waiver. Do you have any questions for me, ma'am?
For sitting here in the counsel's table, you also said that I would be shackled.
Yes.
I'm not shackled now. Will I be shackled then?
My understanding is that you were. If you're not, and the only thing you have is your handcuffs.
Correct.
Is that correct?
Correct.
Okay. If that's the case, then you'll be seated at counsel's table with that, as you are without your hand restraints.
Okay, so I would be unbound.
Correct.
Yes, thank you.
All right.
Wow. Wait, so that sounds like she's going to be completely free at the pretrial stuff. She's not going to have handcuffs or the leg shackles on, or the stun cuffs. That's what it sounded like, he said. But during the trial, she'll have the stun cuff on. Sarah unbound. All right.
The other item I have on, yes, sir.
I think the sheriff's office is looking for clarification, and I think I am too.
Okay.
I think the situation is because she has handcuffs on now, she doesn't have leg restraints, but for hearings, when her hands are unrestrained, her legs would be restrained.
Okay, I'm getting a thumbs up from the deputy in the back that that's the case. Is that the standard operating procedure, Deputy Logan? Okay, so ma'am, so I'll clarify my order. For the purposes of any hearings, you'll be hands-free, but you will have leg restraints.
Yes.
That's not going to affect any fair.
All right. There's the clarification, because I thought it would be really weird. They would just let her free around the courtroom. So she will have the shackles on during the status hearings and any other hearings pre-trial. Pre-trial. Once it goes to trial, she'll have hands free, legs free, and the stun cuff on.
Fairness or impartiality, because it's just you and me and the state, and no jurors will see that. Yes,
Also, Judge, when she's being transported from the jail, she is going to be fully handcuffed with the belly chains and all that. We can take those off.
In advance.
Why are the handcuffs pink?
I'm just worried about the
because
fairness
they are
here in the courtroom, especially when we bring in a jury panel. Okay, and for the purposes of trial, ma'am, you'll have no leg restraints, no hand restraints, your hands free, legs free, but you will have the stun cuff affixed to your leg. As identified by Sergeant Barnett, you're gonna have to sign that waiver every day, okay?
Of course, and if I may, if anyone knows, the stun cuff, does it go over clothing or does it have to
It
just?
is under your clothing, as Sergeant Barnett identified. I have a representative from the Public Defender's Office who I've asked to be here. She's gonna have a conversation with you, ma'am, after our hearing, so she can facilitate clothing for you, including pants that would prohibit the jury from viewing that device on your legs.
Yes,
Okay?
thank you.
All right. Does that clarify for you, State?
Yes, I just saw them and I thought that I saw the confusion based on my experience and how it's done.
Okay.
I was a bit confused as well.
Now, ma'am, that doesn't mean that you're going to be able to wander wherever you want in the courtroom. There's going to be spots where you're going to be able to go to. You're not going to be able to walk all the way up to witnesses. You're not going to be able to walk everywhere that you want. There's going to be places that you're going to have to go to. When we get closer to trial, we'll address the box, for lack of a better word, for where you'd be able to go and not go. And I'm going to give the same limitations to the state. Okay?
I understand.
All right.
Fairness.
Are you okay with addressing that later, Counselor?
Yeah, I mean, what I would envision is if she needs an exhibit brought to witness, I have no problem getting up and doing that for her.
I was going to, either you could do it or I was going to have the deputies do it.
It would be more appropriate for the deputies to do it. It would not be appropriate for the prosecution to deliver the defense's exhibits to the witness. That would be improper. That it would be proper, at least in my opinion, it would be proper for the bailiff to do it. Jill Ams with a $5. Thank you so much. The handcuffs are pink, so she can identify as female. No, but okay.
So, ma'am, I envision that because you're going to be able to move about freely and our jurors are not going to know that you have any restraints on you and they're not going to be able to see the stun cuff, you can conduct Any questions or statements or arguments from where you would like to be in the courtroom, either at counsel's table or at the podium here for you. If you need to approach a witness or you need to provide evidence to someone, I'm going to ask you and the state to both provide that information or that document to one of the deputies, and they'll be able to approach the witness.
That is really, really fair. Because you know, in all the other trials, when the prosecution wants to present the witness with documents or something to review, that's when they say, you know, may we approach, or, you know, may I approach, and then the prosecutor or the defense will take the exhibit directly too. She's saying you can't do that. He said, Sarah, you cannot do that. If you have to give something to a witness, you give it to the bailiff. The bailiff will carry it up there. And in the interest of fairness, he's going to put the same restriction, which is not normally on the prosecution, on the prosecution. So the prosecutor also is not going to be able to approach the witnesses, so that the jurors don't go, okay, the prosecutor gets to do it. Did I say prostituter? I hope I said prosecutor. Wow. So the prosecutor gets the same because she's limited. He is limiting the prosecutor. That is one hell of a good judge right there. That's fair. So the jury doesn't go, well, wait a minute. Why does the prosecutor get to do that, but she doesn't? She must be too dangerous. So there we go. I really, really do like this judge.
Okay.
Thank you.
All right. Do you have any questions about the court's ruling or the procedures for you having movement throughout the courtroom during the course of our trial?
No, I understand. And you said that it would be clarified greater once we get closer to that date. But I would like to ask, please, when the time does come for any exhibits or anything to be handed to jurors, yourself or anyone in the courtroom, is it an option for the state or a deputy? Or is it specifically whoever's the closest and can do it faster?
So what I'm going to do, ma'am, is I have spoken with the sheriff's office. I'm going to endeavor to have additional security in the office or in the courtroom, so that there will be a deputy for basically your disposal, be seated closer to you, so that if you have a document that you want to bring to a witness's attention or ask them questions about it, you can hand it to that dedicated deputy for you, ma'am.
Yes, that is my preference, please. Thank you.
That's what I'm endeavoring to try to do.
What a good
Yes,
judge.
thank you.
Okay. Any other questions about the ruling?
No, sir.
Okay, so your motion is granted for the reasons stated on the record.
2 wins.
State anything to clarify.
No, Your Honor.
Okay. All right, the last issue that I had on my list this morning was the scheduling order and notice of hearings that the court entered on August 5 required the jail to provide the every Monday at 9 a.m. commencing August 12, 2024, a representative from the Orange County Jail shall email to my judicial assistant, email provided in the order, all notebook entries from IMS from the prior week, Monday through Sunday, for every issuance of a laptop and USB device is issued to the defendant. I'm simply changing that to close of business from 9 a.m. to close of business at 5 p.m. And that order will be hand delivered to Ms. Boone and e-filed to the state today. Okay. Is there anything else, state, that we need to address?
No, Your Honor.
Okay. Ma'am, is there anything else that you'd like to bring to my attention?
Yes, please.
Yes, ma'am.
In regards to the status report you were just speaking about regarding them providing me with the laptop each day, what is your definition of entries?
The protocol, ma'am, that was read to you, that you were given a hard copy of Monday, and was also mailed to you on, I believe, the 30th, at the appropriate PO box for legal mail. The protocol identifies entries that are in information management system at the jail for when the laptop is released to you and then returned.
Okay, so it's simply just an entry by the officer stating that they gave it to me and it was returned.
Yes.
I'm making that assumption. I'm just relying on what is in the protocol.
Okay, my concern was they're not stating what it was that I looked at for how long and
I don't know
anything.
that they're going to record that information.
Nope, that's not that would be improper to record what she was looking at and how long, etc. Just when it's in, when it's out is what it should be. Brad said, how come the state can bring laptop to court, but Sarah can't bring her laptop into court? I would guess because it's property of the jail, and she's not allowed to take it out of the jail. I would guess, but I would like to think that she would be provided with one or allowed to use her jail one during the trial. I would like to think that, but I don't know. We'll have to see how it goes.
Of the protocol, ma'am. It's just simply when it's checked out and returned under the protocol.
Yes, thank you for that clarification. And then also for the notice of the expected evidence and witnesses at the trial, we didn't discuss the physical evidence. And I know that that was something pending in regards to the media being.
The physical evidence, we're set to review that here in court on September 3rd at 9 o'clock in the morning. And that was identified in the order from the 5th, ma'am, which you said that you got a copy of through the mail. That's in paragraph 5. The state's physical evidence will be reviewed with the state and the defendant on September 3, 2024 at 9 a.m. at courtroom 12A, Orange County Courthouse, and the address of the courthouse. So the physical evidence will be reviewed at that point in time.
Yes, Your Honor, I understand. My question though was, are you still trying to decide or research having the media here?
Yes, ma'am. I pulled the case law on it. I need to review that case law to see if an evidentiary hearing is required. I know that we have a hearing that we had set for August 14th, which was to address a couple of other issues, specifically your motion to receive the hard copy documents. We no longer need that hearing on August 14th at 1:30 because the jail has confirmed that they have space and Mr. Lane's taking care of that today. But I do want to utilize that hearing for, I still want to utilize that hearing since we've carved it out. So at that hearing, we can address the media issue based on the court's review of the case law and determine if we have to have an evidentiary hearing, we can have an evidentiary hearing at that time. And also we can utilize that as a status as to your review, ma'am, of the digital evidence and to confirm that you've had the opportunity to review it. You don't have to finalize it, but just to see where you are in reviewing that digital evidence that the state may be seeking to introduce at trial.
This is for the 14th.
That's correct, ma'am.
And what is the time, please?
1:30 in the afternoon.
Okay, and for the case law that you are researching and referencing, are we able to have a copy of it prior?
Sure. I don't see any problems. The minor decision. I don't know the citation off the top of my head, but I don't have a problem.
I have no problem. I'm familiar with the case.
Sure. Ma'am, what I'll do is I'm going to prepare another order. I'll be able to hand deliver you the one today, changing the Orange County Jail, providing the notebook entries from 9 a.m. to close of business. I can hand deliver that to you today. But in the order that I mail to you, ma'am, it'll provide the case law with regard to the your privacy and media concerns.
Yes, thank you.
And that'll be heard on August 14th at 1:30, in addition to a status on the digital. Now, ma'am, based on the scheduling order that the court entered back on August 5, you have 14 days from today, absent of showing a good cause, to extend any deadlines to provide your objections in writing to that evidence.
Forgive me, it's objections for the
The
evidence from
digital
the state
evidence, the digital evidence only.
of the 2 USB drives from Mr. Lane?
Oh, no, ma'am, the USB drive that Mr. Lane's going to be providing to the jail today that has those 9 items
Oh, yes.
as identified in this notice of expected evidence.
So they've got 9 pieces of digital evidence they intend on presenting at trial. The prosecution does. They're isolated on this thumb drive that they're going to give her. And she's got 14 days to go through those and decide whether or not to object to any of those digital pieces, those pieces of digital evidence that the prosecution has included on their list of things they intend to present at trial.
Evidence that you were provided today.
14 days and I have to write objections?
That is correct. So your objections to the digital discovery will be due no later than August 23rd. And I will put this all in order for you as well, ma'am.
Thank you.
I believe that addresses all of the court's matters that were teed up for today. State, do you have anything else?
No, no.
Ma'am, is there anything else?
I do have this. I made a copy of For you, this letter that I supplied to Captain Di Giovanni.
That's the thing we read yesterday during part one. That was the last thing we addressed yesterday. The letter to Di Giovanni asking about more time to use the computer and those other things.
Upon her return, knowing what I am requesting, I don't know if I'm able to tell you, but it is a basic laptop. I have no internet and I have no phone. I have
No
I'm
phone,
trying to
no
utilize
lights,
the
no motor
classroom that
cars.
is in
Not
our
a
dorm.
single luxury.
I'm trying to have access to a phone. The USB drives, how they're being handled, I feel very uncomfortable with, as I referenced to you prior.
She wants to have she doesn't want the prison people to take custody and store her thumb drive. She wants to be able to keep that in her locked drawer in her cell.
Taken out of the bags, and then paperwork is being removed from those bags, like the protocol security paperwork that I needed to reference, and then they're resealing the bags. The other day, one of the officers took the USB drives upon herself to remove from the bags herself, and then just handed me both the USB drives. I don't know where they go. I don't know who controls them. I don't know how they're stored. And one of my requests was to keep it at my bunk in my locked drawer, along with, of course, the internet, if I could be supplied earphones and headphones for listening, and a word program, just simply to be able to type motions and letters and anything that needs to be documented or recorded. It is simply a basic laptop in order for me to view my USB drives, and just as I stated earlier to you, some of the
That's true, Ms. K. Griff. That is a valid point. She doesn't know what happens to those things after she hands them off at night. They could be deleting things. They're not, but they could be. You can't completely rule that out. If she's comfortable keeping possession of the thumb drives, I think she should be allowed to.
Parts of the USB drives cannot be viewed, which I will discuss with Mr. Lane tomorrow when I visit with him.
Ma'am, well, you could give your letter to the deputy. We will file that in the court file. Part of the reason we had set the August 14th hearing on your motion for the hard copy discovery was that Captain Di Giovanni was returning on August the 12th from a vacation, and we were endeavoring to have a representative from the jail or herself be here for that hearing. So in addition to a status as to your review of the digital evidence, a hearing on the media request, or prevent media from being at the September 3rd discovery viewing hearing, will address your concerns as identified in this letter, and have a representative from the jail, be it Captain Di Giovanni or someone else, here to address those concerns.
Thank you. And if I may say one last thing, please, in regards to the media being a part of my discovery hearing, I am highly opposed to it.
What are you highly opposed to?
That is, I know that I have a lot of my case details that are already online. For me to be recorded, inspecting and testing and photographing, I believe that is my business only, and one bit of privacy that I should be able to maintain, especially being in the courtroom doing so.
You're talking about the September 3rd evidence view, right?
For the media?
Correct.
Correct.
Okay. Again, ma'am, we're going to have that hearing on the 14th.
Thank you.
Okay. All right. Any other questions, ma'am?
No.
Okay. I will see you all on August 14th at 1:30. Oh, thank you. Ma'am, as the attorney from the Justice Administration Commission had identified, he has provided the court via email the pro se packet. I have a hard copy for you, and I'm going to have Ms. Barrios also send you a copy by way of mail. It was already mailed? Okay, we're going to mail you a copy as well, ma'am. Today, I'm going to give this to the deputy to provide to you. This is the pro se packet that the JAC attorney made reference to on our hearing on August 5.
Yes, thank you. And then also the public defender's office, you said, would be meeting you downstairs?
They're going to be meeting you momentarily. be that right here or downstairs, I'm not sure. But they will be meeting you to discuss that. Okay, thank you, Ms. Click. All right, any other questions, Dave?
No, Your Honor.
Any other questions, ma'am?
No, Your Honor.
All right, we'll see you on August 14th at 1:30. We'll return Ms. Boone to the Orange County Jail.
Thank you.
And exit. Stage right. I guess we stage left, considering the judge being the stage. All right, that is the end of the hearing that was last Friday. Now, the hearing on the 14th, which is today, if you happen to be, it's already tomorrow here. But if you still happen to be on the 14th, that hearing is scheduled to start 2 hours from now. I will not be covering that in 2 hours. I don't think they broadcast the hearings live, but after the hearing is over, they provide the video to the media. So maybe Friday, maybe Saturday, we'll have to see. Because all right, here's what's coming up for the rest of the week. Tomorrow is Thursday. It's our retro trial Thursday. We're nearing the conclusion of the Donald Hartung, the Florida v. Donald Hartung witchcraft ritual murder trial that we've been covering for the past 11 weeks. You don't need to, it's a chill stream. You don't need to know what happened the previous 11 weeks. Just watch it and have fun. Friday, I said it could be Sarah Boone. We're planning on with Flux having an unexplained stream, but our guest, who is a Bigfoot hunter, a ghost hunter, and possibly a medium, may be having scheduling problems. She's going to let me know if she can be there. If she can be there at 9 p.m. Eastern, she will be. If not, we'll reschedule it maybe for the 31st. If it gets rescheduled, we'll do Sarah Boone Friday evening U.S. time. If it doesn't get rescheduled, then we will probably do Sarah Boone on a Saturday or something like that. We'll work it out, because starting Monday, there'll be no Maritime Monday this Monday, because beginning on Monday, Megan Fox and I are going to be covering a new issue. There's a very, very interesting case that has come to light that involves people that we know from other hearings. Excuse me. And so we'll be covering that. So that will be most likely all of next week, where we deep dive into this new case that has come to light. So join Megan Fox and I. We still have to work out the logistics of the mutual streaming, the joint streaming of things, but it is going to be something you do not want to miss. Some very familiar names are going to be brought up in that particular matter. So there's your teaser. That'll be most likely all of next week. All right, I think that's kind of all we've got lined up for today. And tomorrow or today here, Thursday is a holiday here in Korea, so woohoo! I don't have to go immediately to sleep. I can hang out and do things. So I'll probably go for a nice little walk while it's nice and cool this evening. I'm gonna have a good evening. What's gonna happen with you guys? It's up to you. But when I close the stream down, we're gonna go over to Broken Baker. Broken Baker is handling Florida versus Susan Lawrence, the neighborhood dispute turned tragic trial. It's day 2, so it's just starting. And I'm going to send you on over there. Make sure you tell Broken Baker hi from Legal Vices. Make sure he knows it's a Legal Vices raid. Yeah, you got here a little bit late, D. What? But see, Winter Storm had a stroke. Oh, God. Damn it. I'm so sorry to hear that. Best wishes, see Winter Storm, for a full and speedy recovery. I sincerely wish you the best. That is sad news. Dang. Thank you for bringing that to my attention. So that's what's coming up in the next week. Join me tomorrow for the zombie undead murder witchcraft ritual murder trial of Donald Hartung and people. Thank you so much. We got to the first achievement today. We unlocked the emotional support potato pig dog cam. That's the 3rd day running. Let's see if we can keep it up for a 4th day. Let's see how long we can keep this streak going. And we came about $70 away from getting to the second achievement. Better luck next time, me. But all right, that's it. We are wrapping up equality. We are, in fact, wrapping up now. We're going to go on over to Broken Baker. And let's see how our like and subscribe poll ended. We currently got 352 people, 366 likes. This is your last call to hit the like button while we're live and to subscribe to the channel. Please hit that subscribe button. You don't want to miss anything on my wildly entertaining channel. At least in my own head, I'm wildly entertaining. And our like and subscribe poll ended in this fashion. It was kind of a tight race here between the. It's a close race for second place. In last place with 18% of the votes, Sarah Boone is Smarter Than You. With 22% of the votes in third place, Sarah Boone Has an Airtight Alibi. And in second place, with 26% of the vote, Sarah Boone is Confused. And leading the pack with 1/3 of the votes, 34%, Sarah Boone Doesn't Know What to Do. That is the end of today's like and subscribe poll. Again, thank you, mods, for just being the best mods that are out there. Thank you so very much. And please accept my thanks, chat, for your continued support, your ongoing support, the super chats, the gifted memberships, and all those other things that you guys do. So appreciated. And thank you for just being here and watching the trial, watching the hearings, and hanging out with me in chat, keeping each other entertained, keeping me entertained, and hopefully I'm keeping you entertained as well. Thank you. Thank you again. And let's go say hi to Broken Baker, shall we? This is me, Legal Vices, saying thank you very much for being here. And whatever you do, please do not forget to enjoy your legal vices. Lorax, peace out.